We're delighted to welcome you to the first webinar in our Procurement Reform series. This webinar will look at some of the new exclusion grounds and also the new provisions relating to modification of contracts during their term under the new Public Contract Scotland Regulations 2015. There are currently two further seminars scheduled. On the 7th of April, we'll take a look at some of the exemptions to utilising the procurement regulations, and we'll also take a close look at the two new procurement processes, innovation partnerships and competitive procedure with negotiation. On the 14th of April, we'll consider the Procurement Reform Scotland Act 2014 and how the two new pieces of legislation interact with each other. All of the webinars in the series will be recorded and will be available on our Vimeo site. Details of how to access these are on the screen at the moment and will be given again later. Before we begin, there are a few housekeeping matters to start with. As this webinar ask questions, please email them across following the webinar, and we'll seek to follow up the questions with you separately after the webinar. In terms of your speakers today and for the Procurement Reform series, I'm Euan Murray, a Senior Associate in the Construction and Special Projects team, specialising in public procurement and infrastructure, based in Edinburgh. Rona Harper, the partner that heads my team, also specialises in procurement and is based in Glasgow. Both Rona and I will present the webinars in the Procurement Reform series. So, moving forward to our agenda for today's webinar, as it's the first webinar in the series, we'll take a quick look at the current status of procurement reform in Scotland in terms of the implementation dates for the new legislation, and we'll then move on to look at some of the interesting changes in the legislation in terms of exclusion grounds which are set out in Regulation 58. We'll then move on to consider the rules that apply to modification of contracts during their term, which is likely to be of interest to both the public sector as they operate their contracts going forward, as well as to the private sector where they're seeking changes to their contracts. Where we have time at the end, we'll then summarise, and as I said before, if you would like to submit questions, we'll seek to follow them up following the webinar. So, we'll begin with a quick run-through of where we are in terms of procurement reform in Scotland. We now have a new set of procurement regulations which implement the new EU Procurement Directive. They are the Public Contract Scotland Regulations 2015, and it's worth noting at this stage that these regulations apply to Scotland only. Therefore, if you're in the private sector, you need to be aware that there are a different set of procurement regulations that apply in England and Wales, known as the Public Contracts Regulations 2015. In terms of the position in Scotland, the regulations were laid before Parliament on 18th of December 2015 and come into force on 18th of April 2016, although there are some elements which have delayed implementation, and we've set those out on the slide. I don't propose to run through each of these in today's webinar, but we did want to flag that not all provisions come into force on the same date. It's also worth noting that the Procurement Reform Scotland Act 2014 also comes into force on 18th of April, as the Scottish Government opted to bring the two pieces of legislation into force on the same date, in order to take a coordinated approach to procurement reform. We'll come back to the Procurement Reform Scotland Act in the third webinar in our series, but it's worth flagging at this stage that there is a separate regime which sits below the provisions of the new procurement regulations, which the public sector will need to operate, and that will also have implications for the private sector. Well, that sets the scene, and now let's move on to the key aspects of today's seminar: exclusion grounds and modification of contracts during their term. So, we'll start with discussion around some of the exclusion grounds. One of the key themes in both the EU directive and also the implementing legislation is the desire to generate better accessibility for SMEs. The first ground I wanted to touch on today relates to the same. Regulation 59.9 sets out that the selection criteria that a contracting authority can use now restricts the minimum yearly turnover that economic operators are required to have cannot exceed 2 times the contract value. This can be increased, but only in duly justified cases, such as by reference to special risks attached to the nature of the works in question. I think this change will be welcomed by SMEs in particular, as one of the criticisms we often heard was that turnover requirements were set in a standard PQQ document, often used by authorities, and weren't always relevant to the contract itself. For example, a standard requirement for a turnover of 10 million when the contract itself was only valued at 200,000. This should prevent that scenario and will require contracting authorities to actively consider and set an appropriate turnover requirement at the outset of the procurement. In terms of exclusion grounds, the regulations now provide for an exclusion ground for breaches of social, environmental and employment law obligations. This is set out at Regulation 57.2 and allows an authority to decide not to award a contract to the tenderer submitting the most economically advantageous tender, where the authority has established that the tender does not comply with applicable obligations in the fields of environmental, social and labour law established by EU law, national law or by specific provisions listed in Annex 10 of the EU Directive. In addition, there is now an exclusion ground for failure to meet tax or social security obligations. This can be both a mandatory exclusion ground and also a discretionary exclusion ground. So where does the distinction lie? Well, if the breach has been established by a judicial or administrative decision, making tribunal, for example, having final and binding effect in accordance with legal provisions in the country in which it's established or in accordance with any of the jurisdictions in the UK, then there is a mandatory exclusion ground. Where, however, there has not been such a decision, but the contracting authority can demonstrate by any appropriate means that the economic operator is in breach of its obligations relating to payment of taxes or social security contributions, then the authority may exclude that economic operator. So when does this exclusion ground expire? Well, it ceases when the economic operator has fulfilled the obligations by paying or entering into a binding arrangement with a view to paying the taxes or social security contributions due, including where applicable any interest due or fines, or alternatively when the payment obligation itself ceases. Regulation 58.3b also now provides for a mandatory exclusion ground where the contracting authority is aware that the economic operator has committed an act that is prohibited under the Employment Relations Act 1999 Blacklists Regulations 2010, and the commission of such an act has been either admitted by the economic operator or established by a judicial decision making body having final and binding effect. We'll come back to timescales and the potential for self-cleansing shortly. The final exclusion ground, which I wanted to touch on today, is exclusion for past poor performance. One of the complaints often made by the public sector is that they have to continue to allow tenderers to bid for contracts even where they have repeatedly failed to perform in the past. Until now, authorities have had no clear definitive way to exclude bidders for past poor performance. However, this has now been expressly provided for in the new procurement regulations. Regulation 58.8g allows an authority to exclude an economic operator from participation in a procurement procedure where the economic operator has shown significant or persistent deficiencies in the performance of a substantive requirement under a prior public contract, a prior contract with a contracting entity, or a prior concession contract, which led to early termination of that prior contract, damages or other comparable sanctions. At the moment, it's not clear what other comparable sanctions are. However, given that the two named sanctions are early termination or damages, it's fairly clear that the sanctions must be significant. This will be welcome news for the public sector, where they're seeking to ensure that contractors that have failed to perform cannot participate in a subsequent procurement. However, it does raise one interesting point. In order to rely on this exclusion ground, there must have been a contractual sanction applied. For authorities that may wish to use this exclusion ground, it is therefore more important than ever to operate your contract and use the contractual levers available to you, so that you ensure that where things have gone wrong, you can take account of that in the next procurement. Interestingly, it's not clear at present whether the sanction has to relate to a contract with the procuring entity itself, or whether it can relate to any contract with any contracting authority. It is also not clear whether, when disclosing such sanctions, details need to be provided for all group and subsidiary companies, or simply that economic operator itself. Many entities use special purpose vehicles for individual contracts and projects, particularly where they are complex. And as such, if the provision is limited to each individual economic operator, that has the potential to erode the usefulness of this provision for the public sector. In terms of the timescales for exclusion, for blacklisting practices or past poor performance, the period is set at 3 years by Regulation 58/12. There is, however, a longer 5-year period for the exclusion grounds set out at Regulation 58/1. That said, the regulations do introduce the concept of self-cleansing, which allows economic operators that have fallen foul of either Regulation 58/3b, which relates to blacklisting offences, or Regulation 58/8, which relates to past poor performance. This is set out at Regulation 58/13, which provides that an economic operator that is in one of those situations may provide evidence to the effect that it has taken measures sufficient to demonstrate reliability, despite the existence of a relevant ground for exclusion. If the authority is satisfied that the evidence provided is sufficient, then the authority must not exclude that economic operator. In terms of the measures taken, the economic operator must prove that it has either A, paid or undertaken to pay compensation in respect of any damage caused by the criminal offence or misconduct, B, clarified the facts and circumstances in a comprehensive manner by actively collaborating with the investigating authorities, and C, taken concrete technical, organisational and personnel measures that are appropriate to prevent further criminal offences or misconduct. The measures taken by the economic operator must be evaluated by the contracting authority, taking into account the gravity and particular circumstances of the criminal offence or misconduct. And where the contracting authority considers that the measures are insufficient, then the authority has to give the economic operator a statement of the reasons for that decision. Let's move on now to look at modification of contracts during their term. These provisions are set out in Regulation 72 of the new procurement regulations, and these effectively build on and codify the position that flowed from the Precitex case. The provisions set out at Regulation 72 should provide a very useful framework for the public sector in terms of identifying whether a proposed modification is likely to be viewed as a change to an existing contract only, or whether it's actually something that should really be the subject of its own separate procurement. In practice, many contracting authorities will know that complex contracts run for multiple years, and it's highly likely that there'll be a number of changes in any given contract over its life. One of the interesting aspects in Regulation 72 that's worth noting is that in relation to one of the grounds, where several successive changes are made, it is the net cumulative value of those successive modifications which is used to determine the thresholds. We'll come back to that slightly later when we discuss that specific ground. So, what are the relevant grounds? We'll now move on to consider each ground in turn. The first ground applies where the modifications, irrespective of their monetary value, have been provided for in the initial procurement documents in clear, precise and unequivocal review clauses, which may include price revision clauses or options, provided that such clauses 1. State the scope and nature of possible modifications or options, as well as the conditions under which they may be used, and 2. Do not provide for modifications or options that would alter the overall nature of the contract or framework agreement. This will be welcome news for those contracts with complex change mechanisms, such as, for example, hub projects and NPD projects in the public sector, as it means that the changes that are likely to be progressed throughout construction of the relevant infrastructure and the ongoing operation and maintenance of those projects are likely to be provided for and allowed in terms of the regulations. However, what this ground does mean is that careful consideration will need to be given to contracts that currently contain more generic change provisions. Widely drafted generic change provisions are unlikely to comply with the requirements set out at 1 and 2 above, and should therefore be avoided. Failure to provide for detailed change provisions may result in you having to run a new procurement. So moving on now to the second ground. The second ground applies to modifications to provide for additional works, supplies or services by the original contractor that have become necessary and were not included in the initial procurement, where a change of contractor cannot be made for economic or technical reasons, such as requirements of interchangeability or interoperability with existing equipment, services or installations procured under the initial procurement, and which would cause significant inconvenience or substantial duplication of costs for the contracting authority, provided that any increase in the price does not exceed 50% of the initial contract value. Each of these requirements appear to be cumulative, so both limbs 1 and 2 on the slide must apply, and in addition, the increase in price attributable to the modification cannot exceed 50% of the initial contract value. In practice, a contracting authority seeking to rely on this ground would need to consider on the facts of each modification where these circumstances apply. Moving on to look at the third ground. The third ground applies where all of the following conditions are fulfilled. 1. The need for modification has been brought about by circumstances which a diligent contracting authority could not have foreseen. 2. The modification does not alter the overall nature of the contract or framework. And 3. Any increase in price does not exceed 50% of the initial contract value or the value of the framework. This ground will provide some flexibility for contracting authorities where unforeseen issues arise, provided that the change doesn't affect the overall nature of the contract, and of course provided that any increase in the price doesn't exceed 50% of the initial contract value. Moving on now to look at the fourth ground. The fourth ground applies where a new contractor replaces a contractor where the contracting authority had initially awarded the contract as a consequence of an unequivocal review clause or an option in conformity with subparagraph A of that regulation, or 2, complete or partial succession into the position of the initial contractor following corporate restructuring, including takeover, merger, acquisition or insolvency by another economic operator that fulfills the criteria for qualitative selection initially established, provided that this doesn't entail other substantial modifications to the contract or the framework and is not aimed at circumventing the application of this part of the regulations. This ground is clearly intended to catch procedural replacement of a contractor where it's been provided for in the contract or where required due to practical issues such as corporate restructuring and insolvencies. The fifth ground applies where the modifications, irrespective of their value, are not substantial. We'll come back and look at this one in a little more detail, as this ground effectively extends the concepts from the Precitex case. The final ground applies where the value of the modification is below both of the following values: the relevant thresholds mentioned in Regulation 5, i.e. the thresholds for application of the procurement regulations, and B, 10% of the initial contract value for service and supply contracts or frameworks, and 15% of the initial contract value for works contracts or frameworks. provided, again, that the modification does not alter the overall nature of the contract or framework agreement. Going back to the point I made a few slides back, for this ground, where several successive modifications are made, the value for the purposes of ascertaining whether the 10% or 15% limit has been exceeded is the new cumulative value of all of the successive modifications. This is important as many contracts, particularly construction contracts and service contracts, will have multiple variations. And while some of those do not trigger these thresholds initially, it's fairly easy to envisage a scenario where several successive modifications. It will therefore be very important for authorities to maintain an accurate and up-to-date change register where they're relying on this provision in order to enable them to track cumulative value and determine when a modification has the potential to trip that value. So, as mentioned on the previous slide, one of the grounds applies where the modification is not substantial. What does this actually mean in terms of the regulations? Well, Regulation 72.8 sets out the parameters for determining when a modification would be classed as substantial. It provides that a modification will be classed as substantial where any of the following apply. A, the modification renders the contract or the framework agreement materially different in character from the one initially concluded. B, the modification introduces conditions which, had they been part of the initial procurement procedure, would have 1. Allowed for the admission of candidates other than those initially selected, i.e. would have resulted in tenderers other than those that pre-qualified being selected to tender or participate in dialogue. 2, it would have allowed for the acceptance of a tender other than that originally accepted. This effectively applies where the change would have resulted in a tender other than the preferred bidder winning or being appointed as a result of the modification. Or 3, it would have attracted additional participants in the procurement procedure. This one is often the most difficult to quantify, as it requires authorities to consider whether the modification, if made, would have resulted in parties that did not originally bid coming forward to bid for the contract. This could be the case where the risk profile changes or where the services differ from those originally identified in the procurement documentation, or in many other situations, and it will be important for contracting authorities to consider this carefully when considering whether an amendment is substantial. C, the modification changes the economic balance of the contract or the framework agreement in favour of the contractor in a manner which was not provided for in the initial contract or framework agreement. D, the modification extends the scope of the contract or framework agreement considerably. This one's fairly clear and effectively prohibits expansion of the scope of the contract beyond the originally envisaged scope. Or E, a new contractor replaces one to which the contracting authority had initially awarded the contract or framework in case of 22(1)(d). Contracting authorities will find the codified list in the regulations helpful in determining whether or not a modification would be deemed by the courts to be substantial. Although even with this codification, there are still some grey areas, notably determining whether the change being considered would have attracted different participants to the competition, and authorities will need to consider the facts of each modification. What about changes that aren't specifically covered by any of the grounds we have talked about today? Well, Regulation 72.9 provides that a new procurement procedure, in accordance with the regulations, is required for any modifications to the provisions of a contract or a framework agreement other than those provided for in Regulation 72. Finally, I would also flag that the provisions of Regulation 73, termination of contracts in the new procurement regulations, also relate to modification of contracts. Regulation 73 provides that a contracting authority must ensure that every public contract or framework which the authority awards contains provisions enabling the authority to terminate the contract or framework where A, the contract or framework has been subject to substantial modification, which would have required a new procurement procedure in accordance with Regulation 72(9). B, the contractor has, at the time of contract award, been in one of the situations referred to in Regulation 58(1), exclusion grounds, including as a result of the application of 58(2), and should therefore have been excluded from the procedure. Or C, the contract or framework should not have been awarded to the contractor in view of a serious infringement of the obligations under the treaties and the directive that has been declared by the Court of Justice of the European Union in a procedure under Article 258 of the TFEU. The interesting point to note here is that Regulation 73 requires public contracts and frameworks to contain provisions enabling the authority to terminate where there has been a substantial modification which would have required a new procurement procedure in accordance with Regulation 72(9). As you can see, the consequences, therefore, for failing to consider whether a proposed modification is substantial could be serious for the underlying contract and not just the change itself. The regulations further provide that the provisions can address the basis on which the power is to be exercisable by providing for notice of termination and provisions setting out the consequences of termination, and they further provide that where the contract or framework agreement does not contain these provisions, then power to do so on giving notice to the contractor is stated to be an implied term of that contract. What is interesting here, therefore, is that the threat of termination is likely to mean that it is also in the private sector's interest to ensure that any modifications which could be considered to be substantial are fully considered in order to determine whether they fit within the remit of Regulation 72(8). We've now come to the end of today's webinar presentation, which I hope has been useful and interesting. As I mentioned at the start, if you have any questions, please send them across to either me or Rona Harper after the webinar, and we will seek to follow up with you as soon as possible. This slide has our contact details set out to enable you to get in touch with either of us. While you're noting down the contact details, I'll take this opportunity to remind you that all of the webinars in this series will be recorded and will be available on our Vimeo site. So please do share the link with colleagues who you think may find this webinar useful. We'll be circulating details of the recordings to participants after each of the webinars, and we would also appreciate any feedback that you have on the format and content of these webinars so that we can continue to improve them. And we are particularly happy to hear your thoughts on topics which you would like to see covered by future webinars, whether that relates to procurement reform or any wider webinar topics. Well, unfortunately, I think that our time is up for today. I do hope that you've enjoyed this webinar and found it informative and useful. We look forward to welcoming you to future webinars.